Okay, we're live.
All right, welcome everybody. Today we are going to be talking about sovereign immunity that is basically a legal status owned by indigenous groups that provides protection against patents. But before we get into those finer details, I want to give a little bit of background and introduction about Porta Sophia. Because our presentation today is sort of led to that connection through an interesting route. And so my name is David Casimir. I am one of the co-founders of Porta Sophia, and I am a patent attorney by professional training. Porta Sophia was founded to prevent improper privatization of nature and ideas, and primarily by preventing people from patenting things that should not be patented. Specifically, we try to prevent the privatization and monopolization of nature, historic traditions, and public domain ideas in the field of psychedelic medicine. And the gist of this is, if people can get patents covering nature or historic traditions or public domain ideas, they can do things to prevent people from practicing what should be free for all to practice. And the reason we focus this in the area of psychedelic medicine is we observed a very, very specific and kind of extreme problem with patenting in this space. Specifically, prior to us doing the things we're doing now, we noticed that 68% of overly broad patent applications in the field of psychedelic medicine were actually being granted as patents. And let me give a little bit more background on that. When someone has an idea that they think should be patented, they file a patent application with the United States Patent and Trademark Office or other patent offices around the world. And those applications are reviewed by a professional staff to determine whether they are new and sufficiently innovative that they deserve a patent being granted. And if that patent is granted, the owner of that patent essentially has a 20-year monopoly where they can control that technology that's the subject matter of the patent. And one thing we've done at Porta Sophia is to review all of the patent applications and patents that are publicly available in the psychedelic medicine space and assess them for whether they're appropriate, meaning they actually cover a true technological innovation, or whether they're overly broad, meaning they're covering something that's already known and where a patent should not have been granted. And going back to this statistic again, in this earlier time period, we're seeing that well over half of the patent applications that are overly broad, meaning they should not have been granted, were in fact being granted. And that was fairly alarming. And I can say from my personal experience in the patent field for the last 25 plus years, that number is higher than any other field that I'm aware of. Occasionally, a overly broad patent application will improperly be granted, but you would expect that to happen at a very, very low rate. Ideally, you wouldn't see more than maybe 5% of such applications being granted by mistake. So why the very, very high numbers in the field of psychedelic medicine? The main explanation for that we've observed is that patent reviewers typically assess these things to determine if they're new by looking at peer-reviewed publications, by looking at older patents, and looking at sort of commonplace areas where scientists would document their earlier findings. And because of the unique nature of the history of psychedelic medicine, most of the earlier work that is out there and publicly available does not appear in peer-reviewed publications or earlier patent applications or traditional areas where publications happen. And basically what was happening is the patent reviewers just weren't finding this information that was quite readily available if they knew where to look. They just didn't know where to look. And that's largely what was leading to these overly broad patents. And I want to give some examples of some of the patents that have been granted to show the extent in which these mistakes have been made. So on this slide, the first patent is patent number 11235110. This is a patent that was granted by the US Patent and Trademark Office and broadly covers the idea of a vape device for vaping DMT or related compounds, such as 5-MeO-DMT. Now, that's not a new thing. People have been doing that for decades, and for decades prior to this patent application being filed. Yet it was filed and granted. And interestingly, the inventor on this is not a sort of professor at a university or a scientist at a company, but a patent attorney who I think saw an opportunity to potentially get a patent and was in fact granted one. Another example that got some press and is a bit controversial was someone obtained patent number 11-045454 on the idea of using LSD to treat food allergies. And actually, it's interesting, when this application was filed, it was broadly filed for the use of any psychedelic agent to treat food allergies. The patent office asked them to pick one drug to start with and then go back and pursue the others later. They chose LSD for their first choice, and that patent was granted. And of course, this is not something that's new either. This is a recently filed patent application. And for years, people, to the extent that LSD does treat food allergies, people have been receiving the benefit of that for decades and decades, because many, many millions of people have taken LSD. Those that had food allergies, if in fact LSD does provide a benefit, would have been receiving that benefit. So this is a patent that should not have been granted. And indeed, again, this was another curious one in that it was not filed by what you'd call traditional scientists. The owner is a Silicon Valley investment group called Palo Alto Investors LP. And it's not clear that they actually did any experimentation or discovery here at all. There was no data in the patent application. It was just an idea. A third example, and this is from Europe rather than the United States. We have European patent 3927337 that was granted for the use of 5-MeO-DMT for treating treatment-resistant depression or major depressive disorder. And again, this has happened for decades prior to this patent being filed, but yet another example where another patent office here in Europe was not able to find the prior art and granted a patent that should not have been granted. And since Porta Sophia has been founded and running, we systematically look at all new patent applications as they're published to review them to determine whether they're overly broad or not. And we've seen hundreds of overly broad patent applications that are currently pending in the Patent Office in the United States and in other countries around the world. And there's been some relatively famous ones that have gotten a bit of press. One of them is a patent owned by the company Compass Pathways that attempted to patent psilocybin for the treatment of depression. And again, that was known long before they filed their patent application. And this patent application was particularly controversial because it covered concepts such as the set and setting in which the treatment happened, including use of comfortable furniture and having music in the room. Good news here is these particular patent claims have been canceled. Porta Sophia intervened in this case and provided information to the Patent Office. And shortly after we did that, Compass Pathways amended their patent application to make it much more narrow and to get rid of the controversial set and setting claims. So seeing these problems, you can say, well, so what if people are getting these overly broad patents? How is that going to impact anyone in the world? And what I want to highlight on this slide is it can have a really significant impact in a number of different ways. And underlying this is sort of the legal benefits that a patent owner gets. Like, what do you own when you own a patent? In the United States, what you own is you basically have the exclusive right to stop others from doing the four things listed on the slide here: from making the invention, from using the invention, from selling or offering to sell the invention, or from importing the invention. And when you consider those four things collectively, it's a very, very broad set of protections. So for example, if a patent owner has a patent on the use of psilocybin for the treatment of depression, they can stop anyone in the United States from using psilocybin to treat depression. And that would mean drug companies selling the drug for that specific purpose, labeled for that particular purpose, potentially hospitals and doctors administering the drugs, or patients themselves or caregivers or family members who are using the drug for that purpose. all of them are susceptible to a lawsuit by the patent owner. And that lawsuit allows the patent owner to ask for money for the violation of the patent, as well as a legal right called an injunction. It's essentially a court order telling the person who's using the technology that they must stop using it going forward. And one of the reasons these patents become so potentially problematic is kind of an inherent issue with the way patent fights are managed in the United States and the way the legal system is set up. And that is, they're extraordinarily complicated and extraordinarily expensive. A patent fight typically costs millions of dollars to execute from the time the lawsuit is filed through to the end of a trial, if it proceeds through the trial. And because it's so expensive, most people can't afford to defend themselves from a patent owner that has a lot of resources and that can sue them and bring these lawsuits and challenge them. So you'll have these situations where someone has a bad patent, they can threaten someone with it or actually sue them under that bad patent. And the person who's been sued isn't in a financial position to defend themselves. If they were, they might be able to say, this is a bad patent, this should never have been granted, and they could ask a court to say that the patent is no good, and courts do have the power to cancel bad patents. But if you don't have the money, you can't wage the fight. And so at the end of the day, that means individuals who get sued, or small companies, or small groups, or small healthcare settings that get sued typically can't defend themselves. What it also means is that small companies who might be trying to develop these technologies and bring them out into the world, get them FDA approved, get them sort of legitimized in legal settings, probably can't raise the funds needed to develop their drugs because investors don't want to put money into companies where they're going to get sued and have to spend all of those investment dollars on lawsuits rather than research and development activities. So bad patents can have a lot of bad impacts. So what is Porta Sophia and how has Porta Sophia acted to counteract these bad patents? One of the ways Porta Sophia has done this is to create a free, easy to access online library that includes now thousands of historical examples of the prior work that's out there. So the team at Porta Sophia has scoured the universe with lots of helpers who have volunteered their time that are either associated with Porta Sophia or who have volunteered to help to discover all of the prior work, whether it's in obscure libraries somewhere, in rare collections, on websites, all of the places where patent examiners tend not to look. And we've compiled all of this information into this online library with human curated information, which you're seeing on the screen here, identifying all the keywords, the relevant drugs, the topics, making it extremely easy and efficient for anyone to find out whether these alleged innovations that people are trying to patent are in fact new. And so it's a great resource to quickly answer the question that the patent offices were having a very challenging time answering previously. In addition to this, for what we have identified as some of the worst offending patent applications, we've directly reached out to the patent office through a process called third-party interventions. And the way this works is you can submit, and anyone can do this, submit prior work directly to the patent reviewers who are looking at particular patent applications, revealing the fact that these technologies are not new to the potential patent applicant, but were in fact already known. And we filed over 100 of these third-party interventions now, which from what we can tell is perhaps the most anyone has filed, certainly by far the most anyone's filed in the field of psychedelics. And many of these have been extremely successful. Most of them are still in the process, so we won't know the outcomes for another year or two. But the ones that we filed earlier have been successful in getting the patent applicants to either abandon their patent applications, to amend their patent applications to make them much more narrow and no longer overly broad, or to cause the patent office to reject them and essentially not give up and prevent the patent applications from being granted. So this route has been very, very successful in going after some of the worst offenders. Another thing we do is a lot of outreach and collaboration. We talk to many different groups, we answer questions, and we help wherever we can. And through those efforts, we've received a question several times, which is, are indigenous practices at risk from these bad patents? And these indigenous practices can take a number of different forms, but just as a sort of a shortcut for kind of a lot of the conversation we're having today, we'll largely be talking about use of psychedelics, oftentimes in their natural plant forms by indigenous groups in the Americas. This could be in the United States, but also Central America, South America, and elsewhere. Use of things like peyote and ayahuasca and any number of other plant-based medicines. These practices, in many cases, have gone on for hundreds, in some cases, thousands of years. Some of them may be more modern in some instances, but they're old relative to the patent applications that people are trying to file now. And I can say from our work at Porta Sophia that some of these overly broad patent applications that are being filed do intend to encompass use of natural plant medicines for a lot of the practices that indigenous groups have been using them for many, many, many years. So they do, in theory, pose a threat. Now, the good news we're going to talk about today is that indigenous groups have an extra insurance policy that avoids the threat of these bad patents that many others do not have. And that comes from the concept of sovereign immunity. And this is a topic that I think a lot of indigenous groups know about from other legal issues that the sovereign nations have experienced over the years. But there's been very little discussion about this related to patents that we could find anywhere. And so one of the things we wanted to do is make sure that this information is more publicly known. And before I get into sort of the specifics of patent law, I want to give a little bit more general knowledge about sovereign immunity. So sovereign immunity is a legal doctrine by which a sovereign or state cannot commit a legal wrong and is immune from civil suit or criminal prosecution. And as it applies to indigenous groups, it means that as recognized independent nations, these independent nations are generally protected from lawsuits in both state and federal courts, unless one of two conditions is met, either one, that the group waived their immunity, or two, Congress has directly interacted with a specific subset of law and said that this subset of law is not immune under sovereign immunity. And so the big question here is, what about patent lawsuits? How do those fall into this question of sovereign immunity? And the interesting issue here that, as I mentioned, does not get a lot of coverage is there is sovereign immunity, and it's quite strong. And the first time I think this was directly addressed by the federal courts, at least from what I've seen, is a 2005 district court case called the Home Bingo Network versus Multimedia Games, Inc., and the Miami Tribe of Oklahoma Business Development Authority, which is an organization associated with a sovereign nation entity. And this involved a particular patent, which I'm showing some information from here. It's US patent number 6186892. The inventors were Alan Frank and Jane McIntyre, and it was a patent related to a bingo game for use on the interactive communication network that relies upon probabilities for winning. So it's essentially a bingo game that involves some electronic components. And certainly no one here needs to understand the patent claim here, but I've provided it on the right side just so people can get an idea of what does the wording look like in these patents in terms of what someone owns. And the language on the right side of the slide here is the language that Alan Frank and Jane McIntyre, by getting this patent, technically owned. And it's just a lot of really complex language. Some of it was, this claim was so long, I made some of it microprint, so don't worry about the details there. But what happened here was these two individuals sued a native tribe for what they believed was a patent violation of this particular patent. And the native tribe through the Oklahoma Business Development Authority subgroup associated with the tribe, argued that they had sovereign immunity, and the district court looked at it and agreed with them. And so initially, the patent owner asked for two things from the Oklahoma Business Development Authority. They asked for an injunction to shut them down so that they could no longer use the technology, and they asked for money to compensate them for the earlier use. And what I've provided on this slide is a number of quotes from the court itself. And when it's referring to the MBDA, it's referring to the organization associated with the Miami tribe. It says that the MBDA claims it is an arm of an Indian tribe and therefore is entitled to sovereign immunity. So that was the defense that the tribe raised. And then the court went on to say that the tribes enjoy the same immunity from suit enjoyed by sovereign powers, meaning foreign nations or others that are granted sovereign immunity, and are subject to suit only where Congress has authorized the suit or the tribe has waived its immunity. So it's highlighting this general principle of sovereign immunity, that the immunity exists unless one of the two conditions is met, either that the tribe has waived their rights or that Congress has said, this is an area of law, in this case patent law, where sovereign immunity does not apply. So the court went on to address those questions. It said to abrogate tribal immunity, Congress must unequivocally express that purpose. To relinquish its immunity, the tribe's waiver must be clear. So in other words, for these two prongs, it can't be a gray area. If the tribe relinquished its immunity, there has to be a really clear statement that it did so. And if Congress intended patent law not to be protected by sovereign immunity, it must have been really clear about that. And it went on to recognize that the Miami tribe of Oklahoma is a federally recognized tribe. Therefore, it qualifies for sovereign immunity. And therefore, absent waiver, it is entitled to immunity. And I'll go on to the rest of the sentence, but the court, I note in the bullet point below that there was no indication there was any waiver, and there's been no indication that Congress in any way intended patent law to not apply to sovereign immunity or to exclude it from sovereign immunity, so the rules applied. And then I think on the second bullet point here, a really important point of this decision is this court said that this immunity applies regardless of whether the tribe, the organization associated with the tribe, is engaged in activities off the reservation or whether the activity is commercial in nature. So in making this decision, the court is essentially saying that the activities related to the patented technology need not have happened on the sovereign territory itself. It could happen anywhere in the United States, so long as it was being managed by a sovereign entity. And it does not matter whether it's commercial activity or not. It could be for-profit activity, and it could be anywhere, so long as it was under the control of the sovereign entity, the immunity applies. And therefore, the conclusion was that the tribe won the case and the motion to dismiss the litigation was granted. The litigation went away and the tribe was able to continue to use the technology without challenge from the patent owner. Now, the question is, okay, is that a one-off case? Because sometimes you'll get a district court give a particular ruling and it might not apply more generally. But we saw a number of years later a second case that largely came to the same conclusion. And this is a 2011 case called Specialty House of Creation, Inc. versus Quapaw Tribe of Oklahoma. And this involved a design patent. And this design patent related to a slot machine card holder. And I'm showing over on the right side here a picture of what that looks like. So it's a card holder, like a business card holder, I believe, that's designed to look something like a slot machine. And you might wonder, well, why are people getting into a fight about something like this? And on the bottom here, I've pulled some language from the lawsuit itself, from the complaint filed by the patent owner, which is a company called Specialty House of Creation. And it tells a little bit about the story, the backstory here. So looking at this language, essentially what happened is Specialty House of Creation had sold a number of these items to the tribe in Oklahoma, 14,000 of them originally. Apparently those were used up And these were, handed out to patrons of a casino associated with the tribe. And the tribe then asked for a quote on 25,000 more units. And the complaint goes on to describe some other quotes that were obtained. And then apparently, according to at least the patent holder, that the tribe ended up not buying more units from the company, but made their own version, which the patent owner characterized as being counterfeits. And so that initiated the lawsuit, which was a patent lawsuit brought in district court in Oklahoma. And the court, like in the bingo case, identified that sovereign immunity applied here and that the lawsuit could not proceed. The court concludes that the Quapaw tribe is immune from private lawsuits brought under the federal patent law and that the tribe has not waived its immunity with regard to the suit. Therefore, the suit got dismissed. Now, interestingly, the patent owner tried to be very, very creative to argue that the Quapaw tribe had actually waived its rights over 100 years ago based on a treaty that it entered into around the time of the Civil War. But the court ended up giving that argument no real weight and said that it is beyond doubt that the tribe is a federally recognized tribe and that anything that happened back in the Civil War era did not apply and could not be considered a waiver of its sovereign immunity as it applies to patent rights, and therefore it has the sovereign immunity, and the case was dismissed. So what are the implications of this? Importantly, these district court cases show us that Indigenous practices carried out by at least federally recognized sovereign nations, so there's going to be some question about who gets the immunity and who doesn't, or their affiliated organizations, whether on sovereign land or elsewhere, are immune from patent lawsuits. Patent holders simply cannot pursue patent law against these groups, even if they're directly using the technology in the patent, and even if it's for commercial purposes that could even be competitive purposes with the patent owner. But patent lawsuits are just not available because of sovereign immunity. Now, that's not to say that there won't be other potential legal challenges for any sovereign entities who want to use a technology that might be covered by someone's patents. When we're talking about, specifically, for example, the area of psychedelic medications or medicines, if an Indigenous group wanted to get FDA approval and commercialize. Now, obviously, its traditional practices are going to be shielded here. The patent holders, can't use patents to pursue those activities because of sovereign immunity, in addition to the fact that such patents would be bad patents and there would be a normal defense against them. But there's no sort of need to spend the millions of dollars to fight about it because these lawsuits can be made to go away just on the basis of sovereign immunity. There's no need to prove that the patent was a bad patent and shouldn't have been granted. There's sort of an out to the multi-million-dollar costs that others would have to face. But if a sovereign entity did want to commercialize with that patent immunity, it doesn't mean there's not going to be other challenges from the regulatory side or other things that creative corporate entities might try to do to get in the way of a sovereign entity trying to practice sort of commercial use of psychedelic medicines. But again, traditional practices seem to be completely safe from the perspective of patents. Now, that being said, continued immunity is dependent on Congress not intervening. Congress does have the ability to change the rules and to say that sovereign immunity does not apply to patent law in the United States any further. It strikes me that that's probably unlikely to happen under the current situation we have. Congress generally doesn't focus on patent law, although oddly enough, they are considering a change to the patent law right now in a number of ways, nothing to do with this issue, but it's generally not a high priority for Congress. And I don't think there would be any incentive, no matter how much lobbying went on, to do anything that would counteract the or to give sort of patent holders the ability to challenge Indigenous groups from their Indigenous historic practices. I can't fathom that happening. To the extent sovereign nations decided to open up drug companies to compete head-to-head with some of the big pharmaceutical companies. One could imagine there might be a lot of money sent into lobbying at that point, and we could, in theory, see some more aggressive action that maybe would get Congress interested. But absent something to that extent, it seems like Congress is unlikely to act here, and that immunity is likely to be a continuing thing going forward. So that's all of the materials I had to present today. I did want to give a thank you to all of the groups who provide support and funding for Porta Sophia. Porta Sophia is a nonprofit organization who seeks to benefit the public. It's a public interest organization, and so we do depend on the generous donations of groups to keep the doors open and keep doing what we're doing. I will note that we have a lot of volunteer work from attorneys. My own work as a patent attorney with Porta Sophia is all volunteer. I've never made a penny from Porta Sophia. Porta Sophia does, though, have a professional staff that is compensated and does amazing work putting together this library, doing these third-party submissions. And to keep the lights on and keep the good work going forward, donations are always appreciated. With that, I will open up to questions or any discussions people might have.
All right, thank you so much, Dave. A couple questions. Can you hear me, actually?
Yes, you're coming through great.
Okay. So how can Indigenous communities use sovereign immunity to challenge patents that exploit their traditional knowledge? And does this process require specialized legal teams or significant legal costs?
Yeah, it's a really good question. So, and it's kind of this is going to be a slightly complicated answer that might not be exactly what you think you would hear, but there is no great way to challenge a patent application or patent that's just sitting out there other than the types of things that Porta Sophia is doing and will continue to do. So I guess, if you're aware of a patent application or patent that looks like it's going to be a problem, point it out to Porta Sophia and we'll be happy to take a look at it. And if it is a problematic patent, it'll be one of the ones we will challenge. And so we'll take on sort of the time and cost to do that. But generally speaking, you don't need to worry about these patent lawsuits unless a threat of the lawsuit is made or an actual lawsuit is brought. So the time in which someone who is in a position to make a challenge is essentially when you've been sued or when a threat has been made to sue you. At that point, you can raise this issue of sovereign immunity and essentially make that threat go away or that lawsuit go away immediately. And that does involve some requirement for a legal team to participate, but you can get the lawsuit to go away essentially. It's not quite day one, but it's like right away early on without incurring a lot of costs. And I will say we have talked about this among the Porta Sophia team members, and this is something that Porta Sophia is willing to help out with. So if anyone listening to this is in a situation where they're part of a sovereign nation that's under threat of lawsuit or has been sued under patents, reaching out to Porta Sophia would be a good first step. We may be able to directly assist in making that lawsuit go away, potentially at no cost to the sovereign nation. So definitely reach out to help. At a minimum, we will be able to help line up the right legal talent to help out in a really, really efficient and hopefully free way. I think, if some of these bad patent holders are out there going after some of these historic traditional practices, it's well worth it for Porta Sophia and others to make an example of them and to make it clear that sovereign immunity does apply and these lawsuits are not to be had and it's wasting everyone's time. And in fact, I think there's arguments to be had that if just a simple communication to the patent holder saying you can't bring this lawsuit because there's sovereign immunity, dismiss it voluntarily. And if they don't and they decide to pursue that lawsuit, I think there would be some grounds to file counterclaims against that party for misuse of the legal system and to potentially ask for attorney's fees. And interestingly, even if you get free legal help in these lawsuits, You can still ask for attorney's fees, the fees that would have been charged had they been charged in many of these cases. So I think it would be well worth to do some example setting if some of the bad players are out there taking actions. But that's essentially, I think, how this would look. There's not a great way to sort of get rid of these applications and patents that are just sitting out there other than what Porta Sophia is doing. And if anyone wants to do that on their own, we're happy to give advice on how to do that. You kind of have to wait for the bad patent holder to take the action. But when they take that action, there's sort of some clear and easy, in theory, paths to make the problem go away quickly.
Thank you, Dave. Another question, is sovereign immunity limited to the US, or do international Indigenous communities have similar legal protection for their traditional knowledge?
Yeah, it's a super good question. My knowledge expands only to the United States. So I can't answer that definitively with respect to any other country. I do know that there are efforts, and in some cases, I believe laws on the books that do at least protect historic practices. Now, does that extend as far as the sovereign immunity in the United States? I don't think so in most countries, but it is. I know there are groups making efforts to make sure that there are such laws or recognized um, guidelines on the books. Through the World Intellectual Property Organization, there are active efforts right now to create standards that hopefully all sort of member countries, and it's many members there are many member countries of the World Intellectual Property Organization to abide by the standards which would protect Indigenous practices and historic practices. This is, though, very important, I think, to pursue in a lot of countries around the world. And I'll pick one specifically here, Brazil. So Brazil is a country with a lot of historic Indigenous practices. It is also a country with fairly strong patent laws. And in fact, in one aspect, they're stronger than the United States, which is to say, in Brazil, it can be a criminal offense to violate a patent, not just a civil offense. In the United States, if you violate a patent, it is not a criminal offense. There are no patent police. The only remedy the patent owner has is to sue the alleged infringer in civil court and to go through a civil lawsuit. In Brazil, it can be both civil and criminal. So certainly Brazil is a region where those types of protections, to the extent they don't already exist, and they may, I just don't know, it would be important to make sure that they do exist.
Thank you, Dave. Any other questions from attendees? Let me just check.
While you're checking, I'll just note if more questions do come up in the future, just send them on. There's ways to contact Porta Sophia on our website, and we're happy to reach out to the community and answer questions one-on-one, or if you want to have a telephone conference or a video conference, we're happy to have conversations. Cece, was there another one?
It looks like there was one more. What about Porta Sophia's mission inspires you on even the most challenging days?
I think everyone will have to, at Porta Sophia, will have to answer that at a personal level. So I'll answer that from my personal level. One of the reasons I was attracted to founding Porta Sophia and have been, energetic and continuing to work with Porta Sophia over the years is I hate bullying. And patents, because of their expense and complexity and the niche area of law they're in, they provide an area for people who want to abuse the system to bully. And I don't get a lot of areas in my life where I get to push back on bullies, but I've been trained as a patent attorney. I've been very fortunate in my life to be trained not just on how to sort of get patents, but also how to fight them in court. I've worked with some amazing people over the years and have been in some very, very large lawsuits, multi-billion-dollar lawsuits involving very, very large, powerful entities. And so I've been trained to fight these things. And until sort of this opportunity came along with Porta Sophia, I didn't see a lot of patent bullying. And now I saw patent bullying, and I was in a position to push back against the bully, and it's exciting for me to do that. So I don't know if that's a good character trait or a bad one, but that's an honest answer for what it energizes me.
That's a great answer. Thank you for sharing, Dave. Let's see. Any other questions? All right. Doesn't seem like there's any more questions. Thank you so much, Dave.
Thank you, and thank you for everyone who attended. And again, if questions come up, don't be afraid to ask. We're here to help.
Thank you.